Welcome, my little couch potatoes, to the comfiest courtroom on the internet. I'm your host, Llama, and it's time for dramatic testimony, overruled objections, and absolutely unqualified opinions. So grab your snuggiest blanket, some delicious snacks, and get ready to watch court with your internet besties. This is Couch Court with Llama. Hello, my little couch potatoes. I made it. I rushed as quickly as I could to get here. Don't worry, it hasn't started yet. Hope you're all doing great. That's why I'm not all set up appropriately, but I'm here, and that's all that matters, right? All right, you guys, what a day it's going to be. Today, we're going to be watching the change of plea hearing for Bryan Kohberger, who on Monday, it was said that Bryan Kohberger has accepted a plea deal, which is supposedly going to be 4 life sentences, life without parole, as well as burglary, I believe. And he's waiving his right to appeal any of this. So after this and sentencing and victim statements, it's over. It's over with. There will be no more talk of Bryan Kohberger. So that's what we're doing here today. Let's say hello to our chatters. Look at you, Wendy, being first in chat again today. I love that. Love that energy. Good morning. Afternoon. Afternoon. I am not good at remembering when it's morning or afternoon, I've learned. But anyway, good afternoon, Wendy. Hope you're doing great. Angie, hey girl. Hope you're doing well. Lady in Gray, good afternoon, babes. Oh, yep. As Angie says, please hit the like button on your way in. That way it lets everyone know that we're live. And there will be some sort of party here today. I don't know what. I don't know what all we're going to do. We may not even be on very long today. We'll see. We'll see how it goes. But either way, we're all here and hanging out, and I love that. Yes, Angie, it has been a wild, a wild day. I have lots of other things to talk about. That's for sure. Hey, Gavin. Good afternoon. Hope you're doing great. Oh, boy. So while we're waiting for court to come, I don't know, is this court normally on time? I don't know if they are or not, but I got it pulled up. Just a second, let me drink some coffee here. I have not drank near enough coffee today. So what else is going on in the true crime world? Well, it came back earlier. The Sean Diddy Combs verdicts came in. 3 not guilties. Hold on, let me pull up so I know exactly which charges are guilty and not guilty, so I don't say the wrong thing. Okay, here we go. So Sean Diddy Combs, and I will finish up Couch Court After Dark this week that talks about all of last week and all the jury stuff that's been going on, but that won't come out until probably the weekend. But whatever, we'll talk about it now. So Sean Diddy Combs will count 1, racketeering conspiracy, not guilty. Count 2, sex trafficking by force, fraud, or coercion, not guilty. Count 3, transportation to engage in prostitution, guilty. Count 4, sex trafficking by force, fraud, or coercion, not guilty. And count 5, transportation to engage in prostitution, guilty. So I think that's interesting. I'm going to say I disagree with the jury about the sex trafficking charges, but that's their decision. So we got to take it. I mean, they sat through court and watched everything. So it is what it is. Unfortunately, in my mind, but he was still found guilty of some charges. I believe the judge is still keeping him in jail since he was found guilty, at least to sentencing. I don't remember what the sentencing is for those 2 specific charges. But, pardon me, Angie has said judge deciding soon if he'll be released till sentencing. Okay. Thank you for the update. Angie's always got all the updates for me. Chloe Albert's Revenge. Hello. Hope you're doing well. Hope you're doing good. Oh, you guys. So that was frustrating to wake up to. Because I think it came in like right. Yeah. Angie posted that at like 10:25, and that's when I woke up this morning. It was like 10:18 or something, and I was like, I'm just gonna drink my coffee and be sad. Good afternoon, Sammy Sunshine. Hope you're doing great. Max 10 years on each count. Oh, interesting. Interesting. Oh, what else is there? Oh, so today we're not going to do any Crystal Rogers coverage today. We will get back into it tomorrow. And I'm going to tell y'all now, tomorrow is going to be a long day, a very long day. We're going to be talking all about the pretrial between the time that the Lawsons and Houck got arrested up into Steve Lawson's trial this year. We're going to be reading a lot of court documents, and maybe some of you aren't familiar. I love reading court documents because that is where a lot of tea is usually. So we have a couple of those that I want to read to you guys. There is also a few video hearings that I also want us to watch. So it is going to be a very long day tomorrow. I may even end up streaming on Friday and the weekend too. Mods, don't worry about that if I do. Okay, you guys enjoy your break, because I found out that Monday through Wednesday, my bathroom is being remodeled. I don't understand why it's happening now because the problem we had with it got fixed in February, and apparently they're now coming to remodel my bathroom. So it's going to be loud. I don't even know if I'm going to be able to stream or what. We'll have to see. But I will say last night, so I'm already PO'd about the Diddy verdict. All right, I'm already upset about that. I am upset about Kohberger taking the plea deal. I'm not a fan of that, but again, it is what it is. And then last night before I went to bed, I was like, oh, I'll check on the Houck's Lawson's trial, see how that's going. Turns out the prosecution rested yesterday, and I'm really PO'd about it. I'm really PO'd. I think you guys, once we get there, I think you guys are probably going to be PO'd as well. After everything we've talked about, I have lots to say. And I'm very disappointed with all this zealous prosecution going on everywhere. Chloe Albert's Revenge became a YouTube member again. Thank you, Chloe Albert's Revenge. Thank you. Appreciate you being here and being a member with us. Raindrops and Feathers. Hi, how are you? Long time no see. Hope you're doing great. But yeah, as I was saying, we will pick up the Crystal Rogers stuff tomorrow and try to get that all wrapped up, because I don't even know if defense is even going to do stuff tomorrow. They're doing stuff today, but I don't know. That's the thing when you get into true crime, especially trials. All right. You're going to come across cases that really make you question the justice system that we have. And I think that's okay, right? It is. Like Karen Reed, we saw zealous prosecution there too. And I don't know what it is about the cases I keep picking out, but it's sort of like, okay, we really, really need to talk about what we bring to trial and charge people with, what is acceptable and not acceptable. Because some of these, I am like, even though you know that it most likely is that person that did it, you still need some sort of evidence. And to have all these millions of dollars spent on all these different cases and not have any actual evidence is appalling. And it sucks because in some cases, right, you're like, that person totally probably did it. Highly likely it was them. Highly likely they're guilty. And you can't put them away on nothing, really, right? Like, I have so many opinions. Today I'm very disheartened. Very disheartened because I think people are not getting the justice that the victims, are not getting justice that they deserve. But you know what? Enough ranting, enough llama rants. That's when I haven't talked to anybody today, where I'm just like, listen to me rant today, guys. Now that Kohberger is pleading out. What are we going to do now? I don't know. I don't know who we're going to cover next. I know that there's a lot of trials that are supposed to be starting this fall that we were interested in covering, but we're like, well, crap, we're going to be doing Kohberger. So there is options of what we're going to cover next. But what they are at this time, I don't know. We'll probably have some better answers for you guys next week. But in Karen Reed, a lot of you asked me, so Llama, what are you going to cover next? And I told you, trials be wild. Okay. You can never really plan for them. They will change in the drop of a hat, and trials will be pushed or canceled. It's craziness. I don't know why I thought planning stuff out a week ago was going to work. I should have taken my own advice, because one out of the 4 cases that I told you guys about last week, we had the Brooks Hauk, Joseph Lawson trial, the one that we will be covering with Crystal Rogers. That did go through, but no cameras, no audio. Then I was like, oh, we'll do Bryson Rivers. It's a death penalty. They're going to trial. Oh, it got pushed to October. So there went that one. Then I was like, oh, I'm really excited about the dentist that allegedly poisoned his wife and tried to plot murders of investigators out in Colorado. That starts in July. I'm really excited about that one. Guess what? Not televised. Well, just opening and closing statements, and verdict is televised, which I have strong opinions about that. Don't like that. Mm-mm. And then Kohberger pleads out, all in the span of a week and a half, you guys. So just nailing it over here of what we're going to watch next. I don't know. I think I'm jinxed or something. It's always the dentist. There are a lot of murdering dentists. I don't know the stats on that, but of all the doctors, it seems like dentists have a thing. But Dope Meditation asks, did I miss everything? No, sir. Nothing has happened yet. They don't have, I'll show you. They don't have a fun little ceiling fan. Like Karen Reed, that's it. That's literally all that's there. So you haven't missed anything yet. I'm assuming they're streaming this, yeah? I mean, everybody's there. So they're probably just late. I don't know. I did hear some of the victims' families will be there. Others, not so much. So I'm thinking that today is just going to be a plea, and that's about it. But we'll see. Thank you. Bev time. Yeah, that's the thing about a lot of courts. They are usually not great with the time at all. They're not great with a lot of things. But that's okay. We get to hang out for a little bit. And I'm glad that it's taken a little bit longer, because I was rushing to get on here. Now, if you guys know of any upcoming trials that you want us to cover, now that our entire lineup is gone, definitely let me know. We'll look into them, and maybe we'll stream them. I want to watch what you guys want to watch too. So as I said, as long as they're not kids ones, I know the Steven Stearns one is in a week and a half. That's for all the CP stuff, and I'm not going to cover that. All right. I'm just going to tell you right now, I'm not going to be covering Steven Stearns. Other people are, and that's great that they can do that. I can't. So I don't really want to go down that road. So anything other than that would be awesome. Oh, good afternoon, Mama Llama. Hope you're doing well. Oh, yes, Brian Walsh. Yes, we were talking about this earlier today, about Brian Walsh. I do think we are definitely going to be I can tell you for a fact we will be deep diving into Brian Walsh. His trial is supposed to be in October. Whether or not it goes to trial, we don't know. But if you enjoyed everything about Karen Reed, okay, the shitty investigations, the players in that story, all right, Proctor, all of them guys, and the nonsense and shenanigans. This is also another one that had me upset this morning as well. All right. They all played a role in Bryan Walsh's trial. So Bryan Walsh is also from that area. His wife disappeared on New Year's Eve, believed that he did it because of his searches and that he dismembered her, right? I mean, yeah. But this is one of those where, again, you don't investigate properly. We cannot, in good faith, find that person guilty. Okay. I mean, we'll see. We'll look into it more. But shenanigans abound, and I hate to say that. Trust me. I do. All right. I think Bryan Walsh is garbage. All right. But we'll see. So we will definitely be doing a deep dive into that for sure. I can promise you that. Dope Meditations, thank you for gifting a YouTube membership. Thank you. You guys are so nice over here. Look at Banshee, also Mama Llama gifting some more memberships. Thank you guys. Congrats to all of our new members. I had said we had a members only tonight, and that's my bad. I was wrong. So we actually don't have one this week, but they will be next week. I got confused on calendars. Time math, you know how it goes around here. But congratulations to all of our new members. We have lots of stuff from members only coming up, and I'm excited about it. Chloe's Albert Revenge says, watch the hearings. They are already going on. It's like the boy band is back together again, except this time Justin Timberlake is fired. Yeah, man. All those names, familiar names. Oh. They don't even warn you. They're like, here we go. Let me boost this down on this. Okay. Look at that. Have it quick. Hi, Kelly. Just in time. Just in time. It's a nice courtroom.
All right, this is CR 0124316665. Defendant is present in custody with counsel, Ms. Thompson, Ms. Jennings, and Ms. Taylor, Ms. Massoff, and Ms. Barlow. The state's present with Mr. Thompson, Mr. Horowitz, Ms. Jennings, and Mr. Nye. Here as well. Am I miss anybody?
I do like their setup here.
Ms. Allen's here as well.
Just saying.
All right. We are here today to entertain a change of plea. Before I start, I want to address some issues of concern and otherwise. First, I appreciate everybody in attendance today being on their best behavior. Please, no outbursts or demonstrations. Any such conduct will result in immediate removal and may result in an inability to attend further court proceedings in this case. I want to point out that there have been calls by some for the public to contact me and my office in an attempt to influence my decision-making in this case.
Ooh, don't do that.
This has been extraordinarily disruptive for court staff and the ability for them to get work done, not only in this case, but in other cases where defendants are entitled to have their cases processed and, frankly, as important, if not more so, for victims to have their cases processed in those cases. It's also highly inappropriate. A court is not supposed to, and this court will never take into account public sentiment in making an opinion regarding its judicial decisions in cases. Courts should, and I always will, make decisions based on where the facts and the law lead me, period. I have not read any of the numerous messages nor listened to any of the numerous voicemails that have been sent to me and my staff. Those have all been forwarded to security and, where appropriate, to law enforcement.
Oh,
I ask that you not continue to mount such campaigns or to send me information like this, because again, it is not appropriate and frankly not something I would take into account when deciding a matter in a case like this. I also want people to understand some very basic concepts about the ideas of separation of powers, what the court's duties are,
oh, we're
and
getting
what the
electric.
duties and the rights of the executive, or in this case, the prosecuting attorney, is. The executive, the elected prosecutor, is the sole authority in deciding what charges to pursue, including whether, as well as what penalties to ask for, and what penalties to pursue, including the death penalty. This court cannot require the prosecutor to seek the death penalty, nor would it be appropriate for this court to attempt to do that. This court, in considering a plea agreement, if it were to reject this plea agreement, cannot force the state to seek the death penalty. My role and power in considering a plea agreement is extremely limited. My role is to ensure that the defendant's plea is given freely, voluntarily, and intelligently. If those things are met, I can only reject a plea, such as the one in this case, where I'm not being asked to agree to the sentence in advance. I can only reject it, for example, if the defendant does not meet or admit to all of the elements of the crime. That is, I can ensure what is called a factual basis to the plea. Finally, I want to offer my apologies to all the families, including the victims' families, the families of the defendant, for the short notice for today's hearing, and I'm sure what must have been the hurried efforts to get here. I, like most everyone else, learned of this plea agreement Monday afternoon and had no inkling of it beforehand.
Oh.
Prior
Oh.
to that time, I was under the belief that this case was proceeding to trial, as had been indicated, and my staff and I were busy continuing to work on preparations to have potentially 10,000 citizens of Ada County come to jury duty starting in mid-July.
10,000. Holy crap.
With the questionnaire process in mid-July. It was, once I learned of the defendant's decision to change his plea in this case, it was important that I take the plea as soon as possible because of the extraordinary administrative efforts that were otherwise attendant to the process of this, getting this trial potentially underway on time, and including the significant process of bringing, again, potentially up to 10,000 jurors to come in and fill out juror questionnaires prior to the beginning of the voir dire process.
It's going to take longer than 2 weeks to sit that jury.
And so it was important that we, if we're going to go down this road, do so expeditiously so that we can avoid those costs and expenses associated with that. Otherwise, if it was not going to result in a plea, or if for some reason the plea were to fall through today, that we could continue diligently towards trial at the time specified. And so that obviously required that we act quickly. And so some folks may have not had the amount of time that we would otherwise allow for them to travel here. And so, again, I apologize for that. I want to make people aware that during the hearing, if you are to leave the courtroom for any reason, you will not be readmitted during the hearing. Also, when we finish the hearing this morning, I ask that the public and media wait in their seats until the victims' families and the defendants' families and others are escorted out of the courtroom before you start to leave. Finally, I want to acknowledge the trial court administrator and her staff, the Ada County Sheriff, and the Ada County 4th District Marshal Service for the huge lift that they've accomplished in preparing for and orchestrating this hearing today, as well as to all the security attendant today that you see, and some of whom many of whom you don't see, with less than 48 hours notice. And so I appreciate the hard work that they've been doing. Frankly, some of them while they were on some vacation prior to the trial starting and had to call that short. And so I appreciate very much their professionalism and dedication. All right. That said, let's move to the business of today.
Wow.
I understand the state and the defense have reached a plea agreement in this case. For the record, I have a written plea agreement which indicates in sum, the defendant will plead guilty to all 5 counts in the indictment, burglary, felony, and first-degree murder, 4 counts. The state and the defendant stipulate, that is, that the defense is not free to argue for a lesser sentence at sentencing to the following. The defendant on the burglary charge will be sentenced to 10 years fixed, and that the defendant on counts 2 through 5, the 4 counts of first-degree homicide, on each count would receive a fixed life sentence, all 5 of those counts to run consecutive to one another. Defendant, as part of the plea agreement, waives his right to appeal, as well as his right to appeal the sentence and his right to seek leniency or reconsideration of the sentence under Idaho Criminal Rule 35.
Is anybody else
This
shocked
is
right
not
now?
a Rule 11 agreement, meaning the court is not bound by the plea agreement and could impose a different lawful sentence at sentencing. The stipulated agreement between the parties is the maximum on each count. So theoretically, the only thing the court could do would be a lesser sentence at sentencing. But the defendant is not free to ask the court to do so under the plea agreement. Are there any other material terms of the plea agreement that the parties would like to make? Obviously, the plea agreement, the written plea agreement will speak for itself and be part of the court record.
Not from the state, Your Honor. Thank you.
No, Your Honor. Thank you.
All right, very well.
So he doesn't have to say what happened?
All right. Ms. Taylor, have you had sufficient time to discuss this case and all of its ramifications with your client?
I have, Your Honor.
Have you discussed fully with him his rights, defenses, and possible consequences to him of the guilty plea?
Yes, Your Honor.
Have you been able to do all the discovery you feel necessary?
Yes, Your Honor.
And have you informed your client of
Yeah.
the importance of providing the court truthful and accurate answers in taking this plea today?
I have.
Have you apprised your client of any and all offers and counter offers and answered his questions about those?
Yes,
Do you consent to the entry of the plea today?
I do.
All right, Mr. Kohberger, I need to ask you some questions this afternoon, or I guess it's this morning still. I do this to ensure that so that I am assured that you understand the nature of the charges to which I understand you're going to plead guilty, as well as the possible consequences to you of your guilty pleas. I want to make sure your plea is given voluntarily, and I want to make sure that you actually committed the crimes to which you're pleading guilty, because I don't want you to plead guilty to a crime you didn't commit. If you attempt to plead guilty today, but for some reason I don't accept your plea, then it is possible that your statements today could be used against you later at trial. Do you understand that?
Yes.
All right, thank you. And now while you're standing, actually, why don't you take the oath from the clerk?
You solemnly swear or affirm that the testimony you shall give in the matter not being before this court shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, and Mr. Kohberger, just to make it easier, you don't need to stand when you speak to me. I appreciate the sign of respect, but for convenience, you can remain seated, all right? Before I start asking you questions today, have you consumed substantive questions? Let me ask you, have you consumed any alcohol, drug, or other intoxicating substance that would impair your ability to understand or exercise reasonable
now.
judgment?
No.
You feel like you are thinking clearly today?
Yes.
All right, I want you to understand what the possible penalties are for each of the crimes to which I understand you're going to offer a guilty plea today. They include on count one, the burglary, a fine of up to $50,000 and a period of incarceration of up to 10 years in the state penitentiary. You may be required to pay restitution to any victims of the crime. Count 2, 3, 4, and 5 for first-degree murder. The consequences include a fine of up to $50,000, a period of incarceration of life imprisonment, which is a requirement of a sentence, that it be a life sentence with a mandatory minimum sentence of at least 10 years on each of those counts. In addition, you would be potentially responsible for a fine of up to $5,000 to each of the victims of your crime to be enforced in the form of a civil judgment to operate as additional punishment. This is in excess of any restitution or fines that the court could order. And again, you may be required to pay restitution to the victims of the crime. You would be required to provide, as to counts 1, 2, 3, 4, and 5, a DNA sample and a right thumbprint impression, and potentially pay for analysis of those samples. You would lose any right to possess, purchase, or carry a firearm, the right to serve on jury duty, the right to hold public office, and the right to vote. Do you understand the charges and all those possible consequences?
Yes.
You've heard the plea agreement that I talked about today. Do you agree with that plea agreement?
Yes.
And do you understand the nature of the charges that are that you've been charged with that I understand you're going to plead guilty today to?
Yes.
As as I indicated, I'm not bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Is anyone other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
Has anyone told you to be untruthful in answering my questions today?
No.
Has anyone offered you a reward of any kind other than the plea agreement in order to get you to plead guilty today?
No.
Oh, yes.
Are you pleading guilty because you are guilty?
It's probably prohibited.
Yes.
And counsel, obviously there have been a number of motions filed to suppress evidence in this case.
It's fair.
Other than those filed, are there any other motions that you felt were available with respect to Rule 12?
No, Your Honor.
And Mr. Kohberger, you understand that by entering the guilty plea in this case, you would be giving up your right to appeal any decision this court made, as well as your sentence.
Yes.
Hello, elbow feet.
Have you had enough time to decide whether or not to plead guilty?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
Given your choices, do you believe it's in your best interest to plead guilty?
Yes.
Have you discussed fully the matter of pleading guilty with your attorney, and are you satisfied with the advice you've received?
Yes.
Has your attorney advised you to your satisfaction about what your rights are, what your defenses may be, and what the possible consequences to you of your guilty plea are?
Yes.
Has your attorney done everything you've asked them to do?
Yes.
Are you satisfied with their representation of you?
Yes.
I have received a written guilty plea advisory questionnaire that is purported to be filled out by you. Did you fill that document out?
Yes.
Did you understand the questions that you answered in this document?
Yes.
And are the answers that are outlined in this document your answers?
Yes.
Are those answers truthful?
Yes.
Did you sign the document?
Yes.
And this document outlines many of the rights that you have in this case. Should you not plead guilty, did you understand those rights?
Yes.
They include a right to a jury trial. Do you understand that?
Yes.
They include a right to the presumption of innocence. Do you understand that?
Yes.
You have the right to require the state to prove your guilt as to each element beyond a reasonable doubt. Do you understand that?
Yes.
They include a right to confront your accusers and cross-examine witnesses presented by the state, including by utilizing the subpoena power of the court to accomplish that. Do you understand that?
Yes.
You understand you would have a privilege against self-incrimination and a right to remain silent, meaning you would not be compelled to testify if you did not wish to, had you not pled guilty.
Yes.
You understand you're giving up that privilege and those rights that I've just outlined by pleading guilty.
Yes.
All right, I want you to understand what the state would have had to have proven at trial had you, to the crimes that you're pleading guilty to, had you, if you didn't plead guilty. Let me find the document. Hang on a second here. All right.
No, I don't think that's what they were saying, guys. I mean, maybe I'm wrong because y'all are kind of saying that, but burglary gets served first 10 years and then the
So as to
licenses
count
are
one burglary, the
after
state
that.
would have to have proven that on or about November 13, 2022 in Latah County, Idaho, you unlawfully entered a residence located at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder. As to count two, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Madison Mogan, a human being, by stabbing Madison Mogan, from which she died. As to count three, the state would have had to have proven that on that same date in Latah County, at that same address, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Kaylee Gonzalez, a human being, by stabbing her, from which she died. As to count four, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Xana Kernodle, a human being, by stabbing her, from which she died. And then as to count five, also murder in the first degree, that on or about November 13th, 2022, in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing him, from which he died. Do you understand those things the state would have had to have proven?
Yes.
And do you understand that by pleading guilty, the state no longer has to prove those things because you're admitting those things are true?
Yes.
I want to also make for the record, the defendant has provided with the guilty plea advisory form a document entitled Written Factual Basis that purports to have the defendant's signature dated 1 July 2025. Did you sign that document?
Yes.
And did you agree with the written factual basis that is included there?
Yes.
And then let me ask you, did you, on November 13th, 2022, enter the residence at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder?
Yes.
Did you, on November 13th, 2022, in Latah County, state of Idaho, kill and murder Madison Mogan, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice of forethought?
Yes.
Did you honor about that same date in Moscow, Idaho, kill and murder Kaylee Gonzalez, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with
No.
premeditation and malice of forethought?
They're not allowed to do that. Okay.
And did you on that same date in Moscow, Idaho,
I'm pretty
kill
sure.
and murder Xana Kernodle, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, with premeditation and malice of forethought?
Yes.
And then on or about November 13th, 2022, again in Latah County, Idaho, did you kill and murder Ethan Chapin, a human being?
Yes.
Did you do that willfully, unlawfully, deliberately, with premeditation and malice of forethought?
Yes.
I would ask the state at this time to provide its recitation of its factual basis had this case gone to trial.
Thank you, Your Honor. Your Honor, the organization of the recitation is different than what I think the court and the public may be familiar with from the probable cause affidavit and other documents. The state's evidence as an overview would show that back in March of 2022, when the defendant was residing in his parents' residence or residing back in Pennsylvania, his home state, he purchased online a K-bar knife and sheath with an Amazon gift card that he had purchased shortly prior to the purchase of the knife, sheath, and sharpener. Jumping ahead, the end of June of that year, the defendant, Mr. Kohberger, moved from Pennsylvania to Pullman, Washington, which is right across the state line from Moscow, Idaho, for the purpose of pursuing a PhD in criminal justice at Washington State University. The state's evidence would indicate that beginning July 9th of 2022, Mr. Kohberger's phone began connecting to a cell tower that serves the area of the 1122 King Road residence in Moscow, Idaho. Now, I will acknowledge for the court and all present that there are many residences in that area. It's a dense population of mostly college-related occupants. Between July 9th of 2022 and November 7th, the defendant's phone connected to that particular tower during late night, early morning hours, 10 p.m. to 4 a.m. on approximately 23 times. Now, I will acknowledge also, we do not have evidence that the defendant had direct contact with 1122 or with residents of 1122, but we can put his phone in that area on those times. In the interim, on August 22nd of 2022, Latah County Sheriff's Deputy Darren Duke conducted a traffic stop in the early morning hour or late evening hours, about 11 p.m. On the west side of Moscow on Moscow Pullman Road. This was the traffic stop of Mr. Kohberger's car, which turned out to be a 2015 white Hyundai Elantra with Pennsylvania plates. During the course of the traffic stop, Deputy Duke was able to obtain Mr. Kohberger's name, Bryan Kohberger, his phone number, and his address, which at that point was an apartment address in Pullman. We then move to the early morning hours of November 13th, 2022. The state's evidence would show that early morning hours on that day, Mr. Kohberger's phone left his Pullman residence, which is an apartment in kind of the central northwest part of Pullman. That phone was then subsequently turned off at approximately 2:54 a.m. and remained off until approximately 4:48 a.m. on Sunday, the 13th of November.
Do you guys hear that echo?
The state's evidence would include at trial video surveillance of a business on the Moscow Pullman Highway, just across the state line from Moscow. It would show a vehicle matching the description of the defendant's Hyundai Elantra entering Moscow at approximately 3:02 a.m.
That's not me.
Compiled surveillance that the investigators put together from businesses and residents then show the defendant's car, the white Elantra, as I've described, circling the 1122 King Road area, that neighborhood, starting around 3:30 or so in the morning. Comes into the immediate area of 1122 King Road, which is actually on a dead end, and then leaves several times. And approximately 4:05 that morning, the defense car had entered that area, was leaving, stopped at the intersection of King and Queen Road, did a U-turn, and the state's evidence would show that defendant's car came back and parked behind and above the 1122 King Road residence. The state believes that its evidence would then show that
not
the
stop.
defendant entered the residence of 1122 through the kitchen sliding door on the back side of the residence, which is the side of the residence that would face the area above where the defendant's car was parked. Defendant entered the residence, went to the third floor, and with a knife, killed Madison Mogan and Caitlin Gonzalez. The defendant, as he left that room, for whatever reason, ended up leaving, or the sheath for a K-bar knife was left on the bed next to Madison Mogan's body. And I can jump ahead. That sheath was tested by the Idaho State Police Forensic Lab, and single source male DNA was found on the snap of that sheath, as well as blood from both Kaylee and Madison and other trace evidence. But it's important to note single source male DNA was on the snap of that sheath. The state's evidence would show that Xana Knodel was still awake at this time. In fact, had taken a DoorDash order not long before this started. Her room was not on the third floor. It was on the second floor on the west side. As the defendant was either coming down the stairs or leaving, he encountered Xana, and he ended up killing her, also with a large knife. Ethan Chapin, Xana's boyfriend, was asleep in their bedroom, in her bedroom, and the defendant killed him as well with a large fixed blade knife. Each victim suffered multiple wounds. I will state for the record that there is no evidence there was any sexual component or sexual assault on any of the victims. I want to make that clear so there's no speculation. There were two other roommates in the house, and they were already asleep. During the course of this, one of those roommates awoke, looked out her door not knowing what was going on, and saw the defendant, who was dressed in black with a black balaclava on, holding some sort of container in his hand. And she saw him leave the house through the direction of the kitchen where that sliding door is that I mentioned before.
Hmm.
At approximately 4:20 that morning, so this would have been 15 minutes or so later, the defendant's car is seen on a surveillance camera for 1112 King Road, which is immediately next door to the west of 1122, leaving the area at a high rate of speed. And if the court were to see that, or anybody in this courtroom would see that, you can see the car almost loses control as it makes the corner, heads north, and then turns to go south on Walenta, which is one of the only ways to get out of that part of town.
Oh boy.
The evidence would show that following that, the defendant in his Elantra drove south of Moscow. We know that he drove on the back roads because there are surveillance cameras on the main highways, Highway 95, that would have picked up the defendant's car if he'd gone that route. And they did not show the defendant's car on that route during the time. So we know that he went through a variety of back roads in very rural, isolated part of Latah County. About 4:48 that morning, the defendant's phone comes back on. And the evidence will show that that phone was located south of Moscow, likely at a side road intersection with Highway 95. From there, the defendant's phone activity tracks heading back north towards Pullman, Washington, where the defendant lived. About 5:26, starting approximately 5:26, various surveillance cameras in Pullman, Washington pick up the defendant's vehicle as he enters Pullman from the south and heads north and slightly west towards his apartment, where he arrived at approximately 5:30 in the morning. Later that morning, Sunday, the 13th of November of 2022, Mr. Kohberger's phone returned to the area of King Road. We don't know exactly what he did, but it returned to that area. It's about 9 o'clock in the morning. It's there for about 10 minutes and then returned to his Pullman residence. About 9:30, the state's evidence will show, evidence taken from the defendant's phone, that he took a selfie of himself on his phone in what appears to be the bathroom of his Pullman apartment with a thumbs up. The defendant's phone then went to the Lewiston-Clarkston Valley, approximately 30 miles south of Moscow and Pullman. And the defendant is actually seen with his car at various businesses down there. This area is the confluence of the Clearwater River and the Snake River. Lewiston is Idaho's seaport, large bodies of moving water down there. In addition to tracing the defendant's activities, as I've just outlined on the 13th and leading up to the 13th, the state's evidence will show that following Sunday, November 13th, 2022, business records show that the defendant began searching for a K-bar knife and a K-bar knife sheath, as the state believes, to replace the one that was left at the scene of the murders. The evidence also will suggest that there were at least attempts by the defendant to delete or alter his purchase history on Amazon, where all these transactions had occurred. Later that week, the state's evidence will show that Mr. Kohberger went to what we would call DMV, motor vehicle licensing here in Idaho, in Pullman, to change his car registration from Pennsylvania to Washington. That's of note because Pennsylvania cars do not require a front license plate. The vehicles seen on the surveillance cameras of the defendant's car showed it didn't have a front license plate on it. At the time of the traffic stop by Deputy Duke in August, it was Pennsylvania plate, no front license plate. Mr. Kohberger proceeded to finish his semester of studies at Washington State University and returned to Pennsylvania for the holidays. Law enforcement at this point were aware of Mr. Kohberger, had been accessing information about him, were trying to find him. They located him in Pennsylvania, and they conducted what's called a trash pull. During the nighttime hours, agents of the FBI, who assisted immensely with this case, working with the sanitation department back in this neighborhood in Pennsylvania, took trash that had been set out on the street for collection, sent the contents of that from the Pennsylvania residence of the defendant's parents to the Idaho State Forensic Laboratory, where the lab experts there were able to identify DNA on a Q-tip as coming from the father of the person whose DNA was found on the knife sheath that was next to Madison Logan's body in the bed. Subsequently, an arrest warrant was issued here in Idaho, and a search warrant was issued in the state of Pennsylvania with the assistance not only of the FBI, but the Pennsylvania State Police. Mr. Kohberger was arrested at his parents' home to return to Idaho. Upon his return to Idaho, a DNA sample was taken from him, and it matched the DNA found on the knife sheath next to Maddie's body at the crime scene. I can tell the court and the public, the weapon itself, the knife, has not yet been recovered. I can tell the court that the defendant's apartment in Pullman was searched, as well as his office. Spartan would be a kind characterization. There was virtually nothing there. Nothing of evidentiary value was found. And of course, we are now talking 6-8 weeks after the time of the killings. In Pennsylvania, the defendant's car was seized, and it was actually pretty much disassembled internally. And it also had been cleaned. There was a bucket of cleaner right beside it. I think we can all look to our own cars, you know, in those compartments in the doors. You can try to keep them clean where you put stuff. There's always some degree of crud in there. They were spotless. The defendant's car had been meticulously cleaned inside. And the state would present to the jury that that was part of the defendant's plan in covering up this. The defendant has studied crime. In fact, he did a detailed paper on crime scene processing when he was working on his pre-doctorate degrees, and he had that knowledge and skill.
I believe a dog was
So,
in
Your
a
Honor,
different room,
in-
Angie.
The state submits that the evidence that I've given just a quick overview of, and that to present in court would consume weeks, which the state is prepared to do and has been prepared to do, would show that as the defendant has just admitted and pleaded guilty on November 13th, 2022, excuse me, Mr. Kohberger entered the residence at 1122 King Road in Moscow, Idaho. He did that with the intent to kill. We will not represent that he intended to commit all of the murders that he did that night, but we know that that is what resulted, and that he then killed intentionally, willfully, deliberately, with premeditation, and with malice forethought, Manny Mogan, Kaylee Gonzalez, Ethan Chapin, and Sam.
Oh,
Thank you.
Thank you. All right, based on the state's proffer and importantly, based upon defendant's explicit admission to committing these crimes, the court finds there is a factual basis. Therefore, with respect to count 1, burglary, felony, how do you plead, Mr. Kohberger, guilty or not guilty?
Guilty.
As to count 2, murder in the first degree, as it relates to the murder of Madison Mogan, how do you plead, guilty or not guilty?
Guilty.
As to count 3, as it relates to murder in the first degree for the murder of Kaylee Gonzalez, how do you plead, guilty or not guilty?
Guilty.
As to count 4, the first degree murder of Xana Kernodle, a human being, how do you plead, guilty or not guilty?
Guilty.
As to count 5, the first degree murder of Ethan Chapin, a human being, how do you plead, guilty or not guilty?
Guilty.
The court will find that the defendant understands the nature of the charges and each offense and the possible consequences to him of his guilty plea. The court finds that there is a factual basis for the plea and that finds the defendant believes the plea to be in his best interest. I find that the plea was given freely, voluntarily, and was intelligently made. I accept the plea. I direct that it be entered. I'll continue the matter for sentencing in this case. I think it was mentioned on the call Monday afternoon, the defense wishes to waive a pretrial investigation. Is that accurate?
Yes, Your Honor.
The state also?
Yes, Your Honor, the state does not believe pre-sentence investigation is needed, given the evidence that is available. We want to, though, make sure that all of the victims have the opportunity to make statements to the court at sentencing.
Absolutely. And certainly both the state and the defense may present whatever sentencing memorandum and other documents you wish me to consider. The victims will be given an opportunity to provide the statements that they wish to at sentencing. Do we need more than 1 full day for sentencing?
I do not believe so, Your Honor. Obviously, we have numerous victims, and we have victims who share unique perspectives on this, and we want to make sure that they all have time to express their feelings to the court. But I believe that if we can start perhaps 8:30 or so in the morning, that we should be able to complete it all in 1 day.
Defense agree with that in terms of the time frame?
Yes, Your Honor.
All right. So as it happens, we have some time reserved in this case in July and August. The week of July 22nd is available. I don't know if that's too soon for the parties or the next week, the week of August 4 is available. Any preference?
Your Honor, we're prepared as soon as the court wants to schedule it.
The state, I believe, would be prepared on the 22nd. We've told the victims' families that we're looking at approximately those dates.
All right. So because of the plan to bring in so many jurors to fill out questionnaires, I had ordered that no other trials could take place in this courthouse the week of July
Wow.
22nd. And so we will use that in terms of the the sentencing date, because of what I'm sure will be the significant interest of the media and the public, and the logistics that will be required to make that happen. Without trials going, it'll be a lot easier to do that. So let's pick that week. Why don't we pick July 23rd with the idea that if for some reason we don't finish, we could continue into the 24th. We'll start at 9 in the morning. Does that give your team enough time, Sandra? 9 in the morning? All right. Any concerns with that date?
No, Your Honor, thank you.
No, sir.
All right. Any reason why I should not rescind the non-dissemination order at this time?
You're right. I think that given the history of this case, it would be best if that remained in place through sentencing. So we have time to make sure there's the ability to completely answer questions. That would be the state's preference and recommendation.
Would have no objection for the order to remain in place through
All right,
sentencing.
I will, at this point, the idea to keep it until sentencing, which time it would be withdrawn in order to give the parties the space and time to prepare to meet what I'm sure will be the deluge of media requests. That's at least my preliminary decision at this point. We can always revisit if it seems to be, for some reason, I should. That said, obviously, I don't think the defendant, a bond was ever set for the defendant. Were it would be revoked. The prior order allowing him to come in civilian clothes is revoked, given his plea, and no longer the presumption of innocence. And in fact, now the actual conviction for the crimes.
They usually
He will
are.
continue to be held at the jail pending sentencing. Is there anything else today?
No, Your Honor, thank you.
I assume that the trial date will be vacated
trial
and those
is-
4 jurors will be released.
The trial will be vacated, and I'm sure that the jury commissioner will get word to those that receive their summons that they won't be required to attend. So that said, again, if you would all please wait for the parties and the victims' families and others to leave the courtroom before you do, I would appreciate it. And with that, we're adjourned.
Wow, you guys. Wow, that was something, right? Like, it's so weird that that even like happened today. I'm just sitting here like after, 2-3 years of this, and that's what it culminated to. It's wild. Hold on, let me fix my YouTube here. I'm gonna switch it over to East Idaho News because they might have some interviews going on afterwards. But we'll wait. Oh, it's just Nate talking. So, hold on, why did I pause that? There we go. Ah, wow. So someone asked, will he be in prison guard? Usually they are at this point, right? So the reason that you're allowed to wear street clothes is so it doesn't cause prejudice, so that the jury doesn't develop some sort of prejudice against you because you're in jail guard, right? But for those that I've seen that have done sentencing after the fact, they're in jail guard because it doesn't matter at that point because you're being sentenced. So there's a likely chance, good chance that he'll be there with chains and all, but maybe not. I don't know. It's a different jurisdiction, but that's usually what I've seen done. Now, so, oh my gosh, there's so much to talk about from that. I wasn't even prepared. First of all, let's talk about the 10,000 people jury pool. That is crazy. I think that's the biggest number I've ever heard. 10,000 people. Not surprising considering, but it's like the whole state of Idaho or something. Like, wow. that's I've never heard a number that big before. Now he didn't just plead guilty there at the end. Yes, he said guilty, guilty, guilty. But the questions that were asked of him by the judge before the state, gave their proffer was him literally admitting that he killed each one of them individually. It was more than just guilty. He was agreeing that, yes, I did that. I taking responsibility for that, which is just wild to hear. Also, when it came to the sentencing, and I think we're all a little confused about this, but it was my understanding, and maybe I'm wrong, it's fine if I am, because I'll be honest, I was just sitting there like in shock that this was even happening right now. But it sounds like, so burglary was max 10 years. He has to do that one. Then 4 life without parole sentences. So all 5 will be consecutively, which means one after another, meaning he has to serve the burglary first, and then he'll start his first life sentence. And then let's say there's a law that changes, you have to do 20 years or whatever. Okay, well, guess what? You then gotta do 20 years on the second count, and so on and so on. So he's not getting out at all, like at all. You don't have to worry about that. It is confusing in a lot of times in trials when they explain the sentencing and stuff. What state is that? That's super weird. Was it New Mexico? Where it was, anyway. And then the proffer that the state gave basically sounds like their opening statements. They didn't really say anything that at least I haven't heard already about the case. So, except that, they believe that Ethan and Xana were collateral damage. It seems that the state believes that too, which a lot of us had kind of already suspected about that. But yeah, it does sound like, yeah, it does sound like that. And hello, Terry. Hello, welcome. Hope you're doing great. Lucy says that's not true. If they change the law, his sentence cannot change to be additional. Well, that was just a hypothetical, but I'm just saying he'd still be in there no matter what. It's not ain't gonna do nothing. And so they're gonna be back July 23rd. We'll definitely be watching that. Bring your tissues, because that's going to be a sad day. And I'm sure, I know some of the families are very upset about this plea deal. I know others are thankful and happy about it. And like I said, yesterday, it's really none of our business. I mean, am I a little annoyed about? Yeah, of course. I want to know, the investigation and all of that. But I mean, if this helps some people get relief, cool. Others it may not. Grief is a very weird and bizarre thing. And I don't think we should tell any of these families what's appropriate on how to grieve or what to be okay with, because I could not imagine. Some people need like all of the answers, and that's okay. And others don't want any of the answers, and that's okay too. But he's never getting out of prison. We don't ever have to, watch an appeal or any of that. So it is, will we ever know a motive? I don't know. There's a lot of stuff that's still under seal. And that will be unsealed. Now, you also heard the judge say that they are all still on a gag order until sentencing. So you won't be hearing much coming out probably about that, which does not surprise me. The same thing happened with Richard Allen as well. The gag order stayed in place until after sentencing. So Yes, July 23rd. Boo. I know. That's Terry's birthday. I'm sorry. Yeah. Yeah. One family said the state of Ohio has destroyed. I mean, they get little to no answers for years, these families. And that's not just Idaho exclusive. Like that is how it goes in courts. You know, remember the state is not there for the family. All right, that's not how that works. And I can imagine that, you know, they've had to. I've heard other families talk about this before. I'm not going to try to put words in these families' mouths or anything like that, but other families in other cases have said, you know, you're left with years where you're not allowed to know a lot of information. You're told not to talk about any of it because it could affect the outcome of the trial, right? So you basically have to sit there with all your grief, with all your questions, alienated because you don't want to mess up anything that is going to get justice, you know, for your family member. So you've just had to sit there and just take it and feel isolated. And then, you know, something like this happens, and I can see how that can be infuriating for people like that. I honestly, I would be one of those people that would be infuriated by it. Some other people not so much, and that's okay. But it's just, this is where things get complicated, right? The human side of it all. You know, the roommates. I'm sure a lot of people too are probably thankful because this was going to be a media circus trial, and we know how bad that can be sometimes, you know, but I think some people were also spared from having to testify and the world going after them, you know. So there's like silver linings, but then I also get that it's garbage. Chloe Albert's Revenge says, correction, the state, well, the Commonwealth of Massachusetts was there for families, maybe that mainly the Alberts McCabe's, not the O'Keefe's, and definitely not Reed's, right? But their families were blue, so that's how that goes. Terry says, as a family member who had a member murdered, not having to face appeals has been a godsend. Yes, I imagine it is. But I can also imagine maybe for some people, fighting that just gives them that fire, you know. But different things for different, you know, people. I'm not really upset that he didn't like get the death penalty or anything. I know some people are really upset about that. I mean, I think I'm upset that there wasn't a trial to find, you know, okay, because I've been questioning a lot of states' prosecution lately. So I don't even know if I think that's just my own bias coming out of all the cases we've recently covered where it's like, you have nothing. But, you know, that's a 3-month trial for the families. I mean, look, Karen Reed was 6-8 weeks. That was exhausting for her. And the families, those details that would come out in the trial, particularly when the medical examiners would come, those details would be out for all the world to see. And I can't imagine that listening to that would be horrible. But, you know. Oh, yes. Raindrops and Feathers says, I'm sure the surviving roommates are battling survival guilt. Absolutely, I'm sure. And that's, if you've been following this whole thing and you wonder, okay, why is all this crazy internet? The stuff that has been said about these roommates has been wild and horrible. Wild and absolutely horrible. So I am glad that they didn't have to testify and all of that. That's true. Misbehaving in Florida, death penalty was not guaranteed if he went to trial. That's true. I mean, because he could have still gotten exactly what he just pled guilty to, which was life without parole. death penalty is a hard one to get people to agree with. I've seen some where I'm like, what? What? That's, I mean, Parkland comes to mind. Speaking of misbehaving in Florida. Oh, well, actually, I don't know if FLA meant that, but I'm just going to assume it does. They didn't pick that one. So, but it's a lot. Yeah, they knew that they had him. I do think they probably would end up agreeing on a death penalty, but we'll never know. And that's okay. I mean, that is very true. You never know what a jury will do. And when it is death penalty on the line, like that's serious. You know, like that is a lot of pressure. All right. We already heard jurors in less trials that aren't death penalty talk about the pressure they were put under. Could you imagine in this case? Like, oh my gosh, it is Florida. Okay. I'm glad we got that worked out. Not to call you out or anything. Raindrop says, I'm for the DP, especially if you take the lives of multiple people. Just my 2 cents. Me too, babes. Me too. But again, though, when it is your choice and your decision, you know, I can't imagine the pressure of that, because I would need things to be like perfect, really. So, I mean, who knows what will come out of all this, you know? What motive, you know, that's the thing too, is like, would the trial have given us motive? Probably not. They don't have to have motive when you go to trial. That's not a requirement. We probably wouldn't get that either, you know, but I imagine that's the one thing that everybody wants to know. Why? For what? Why kill these 4 young college kids that apparently he did not have contact with? That's what the prosecutor said. With that he had never been to the house, and he had never communicated with any of them. At least that's what I took away from the prosecution's proffer there. So, I mean, maybe he just was really into true crime, I guess, but I don't like that excuse, because then it makes it seem like all of us could, and that's not, I don't know. Maybe once, I mean, I know that the FOIA, everybody is going to be getting all those documents from the FOIA. So once those start coming out, I am more than happy to go over them and cover them with you guys as well, because I mean, I have so many questions. And so when those come out, I will happily come on and we can read them together and talk about it. But that's not going to be for probably not till August, maybe September. So, because they're not going to release anything until the sentencing is done. And then with the amount of stuff plus filing the FOIAs, it'll be a little while, I'm sure. Maybe not. Maybe not. Yes, I don't know what Lady in Gray's comment was to that, but you said something earlier, I think it was Lady in Gray, where you wondered if by him pleading guilty, that helps him control the narrative. And I could see that being another reason why it's holding those secrets to yourself, sort of thing. I could see that as a possibility. And I hate saying that, by the way. I hate it. Lady in Gray says, I think for him it was an experiment or like a thesis to see if he could pull off a horrific crime and get away with it. Too bad he's stupid. He didn't do a very good job, really. Yes, Misbehaving in Florida says, I believe he thought he was smarter than everyone and could get away with it at first when committed, but clearly he wasn't. I do get that vibe as well. Raindrops and Feathers says, I don't think he was expecting so many people to be in that house. Well, that's why he's a dum-dum. Like, well, I'm not even going to go into what somebody should have done. We're not going to, we're definitely not going to say those things live on air, but yeah, dumb. Yeah. Too bad for him and too bad for those kids. I mean, honestly, like, it's so sad what happened to them. And again, why? For what? It's going to be, that sentencing is going to be so hard. I'm probably not even going to put makeup on that day, just to let you know, because it's going to be incredibly sad. And like I said, all the family, they can grieve however they want to. If some want to be pissed and angry and rant about it all over, then let them. Others want to be quiet and private. Give them their peace and quiet. I mean, let's talk about what the judge said at the beginning, where he had to educate the public about not sending him shit like they were doing. That is crazy. Okay, that is great. Do not contact the courts trying to apply pressure on a court official to influence their decision. Why would you do that? Okay, because I'm sure those people are like, oh, we need a fair trial, blah, blah, blah. And then they go and try to interfere and put public pressure on the judge. Oh, those people do not know zippy zap about the justice system or trials. I'm just saying, don't freaking do that. Okay, it's crazy. I get you're not happy with how things turned out, and as he said, when you're flooding, so when you like message, especially the judge, right? All that usually has to go into that case file, right? If the judge gets a letter, it has to be entered and all of that shit. So as he explained, those people that were doing that because they were unhappy, they weren't family members, okay? You're just the general public, okay? But as he said, when you're flooding their emails, their phones, there's tons of other cases that people can't work on just because your dumbass on the internet is upset. What about you? You care so much about the victims. What about the victims in all the other cases? Okay? You're wasting resources doing that. And we already waste enough resources as is anyway. Not cool. Don't do that in the future. You know why? Because little people that do that, you're just giving them more ammunition to not stream trials anymore. Okay? With your ridiculous behavior, you're helping that narrative that they shouldn't be filmed anymore, which I strongly disagree with, because they should be on camera for transparency, because there is bananery going on everywhere. So shame on those people. Ugh. I mean, who does that? That's crazy. Don't do that. No, that was not the judge to do that with. Yeah, you don't send the judge shit ever. It's not okay. Yes, to lead these, no, never okay. Never okay. And that could literally jeopardize a case. I don't know why people do that. I hate it. I'm not going to say anything about that lady in gray. But it doesn't matter who it was. Not a good idea. It's a horrible idea. Don't do it. Chloe Albert's Revenge says, that is the downside to the cameras in court. People think that certain things are okay that are definitely not. Someone from Germany emailed the judge and the YSL trial. I forget what that all stands for. And she read it into the record. Yes, because that's exactly what they have to do. Because if they don't, that could be a huge appeal problem. And I get it. People don't like it, but that's just how it goes. Ridiculous. This, hold on, let me find your earlier comment because I just realized those go together. No, I don't think it's that one. Anyway, I'll go back, whatever. You're talking about the paper he wrote in 2020 during finals for a 300 level criminal justice course, which for you guys don't know, that's pretty high up in your education. Kohberger described how crime scene investigators use fiber-free overalls, gloves, and booties to avoid contamination. Yeah, I haven't read. Is that public? That paper? It should be. Maybe it's not now, though. Raindrops and feathers. The only judge that needs to be told what to do is Bev. I mean, night and day, right? Oh, geez. That's something. Yeah, basically how to get away with it. But he still made a bunch of mistakes. So God forbid a case's integrity being compromised. It happens all the time. You missed my rant at the beginning, Juju Bean. I'm so salty about what's happening in Kentucky right now. And people in Kentucky should be pissed. That's all I'm saying in regards to the Rogers trial. But okay, Misbehaving says the professor definitely released details. Not sure about the whole paper. I heard that the one professor, did she end up doing an interview with Bryan last night on News Nation? Bryan Enton? Or is that tonight? Or can she? Because the judge didn't lift the gag order. I don't know. Amos says, this is the judge that got this case in his court, and his opening statement at the hearing was, I'm telling you, I am happy to be here, but why start with an untruth? Yeah. Oh, Chloe Zabert says, the letter from Germany to Judge Whitaker and Young Slime Wife. Thank you. I wasn't even close with that trial was wild. Happened to be constructive though, but still a big no-no. Yeah, it's not. Again, why would we want any judge to feel public pressure to make decisions? Because just because you're like, oh, but this makes sense in this case. No, because if you apply it to this case, you got to apply it to all of them. And trust me, you don't want to do that. You don't want to play that game. It's already happening in places. So, you missed my rant. Don't worry. Oh, I'm so mad about it, Juju. I'm so mad and salty, but we're not there yet. But I think you all will feel the same by the time we do get to covering that trial. Oh, jeez. Stan said, I watched one of the dads of the victims of the BK trial after they found out about the plea. It broke my heart for them. Well, the judge also said he didn't know. He didn't even know that this was happening because they had court all that day. So before they announced the plea agreement with Bryan, right? They were supposed to be having witnesses subpoenaed in from Pennsylvania, I believe. And some of them didn't show up. And the judge was about to ready to, like, a lot of people were not wanting to come in as witnesses, all sorts of stuff. So it was a big day that day of trying to get witnesses to come in or being willing to. It was a big thing. And then as soon as court's over, all of a sudden there's a plea deal. Even the judge was like, literally had no idea that this was even a possibility because they've been, trucking along doing what they need to before this trial. So, young snail life. Yes. Chloe, Bev Canoni needed public pressure. She was unhinged. Correct. I mean, she was unhinged, but also, she's a judge. Unless you are a judge, you shouldn't tell a judge what to do. I mean, we can sit here and tell them that, sure. I don't have a problem with that. But once you start sending stuff and disrupting the entire court system, because as the judge said, it's not just his office. All right. It wouldn't be everyone. There's a line. Right? We can sit here and talk shit all you want. I'm all about it. But don't send stuff to the courts. Don't do that. Lady in Gray says, I'm glad Brian Walsh's trial was taken away from Bev. We'd never know what the Commonwealth and Massachusetts State Police has done, as much as I don't like the potential consequence. Oh, me either. Me either. Well, you guys, people have no respect. I mean, see, no, I don't mean to go on a rant about the internet. I will rant about all sorts of things. I'm just saying the internet makes people feel like they can say and do whatever they want. And that's not how this works. Oh, that's a whole argument for another day. Let me get rid of that there. Chloe's Revenge says, I get that she was a judge, but she gave up much more than the appearance of impropriety. Agreed. Maybe hearing it from outside people can help set her straight. Yes, I do think that, well, I don't know if it's going to affect her or not. I don't know. But I know that even some other judges have now commented about her behavior. Like, what? Like, oh gosh. A judge in Rhode Island, right? That just came out and talked about it. I don't remember. Okay, you guys. Well, I have a lot more work to do for our Crystal Rogers part 4 presentation tomorrow. It is going to be a long day tomorrow. I'm going to be on at 10 a.m. tomorrow. We're going to keep it at 10. It's going to be a long day. All right, we're going to cover all the pretrial stuff from the time that Brooks Howe, Stephen Lawson, and Joseph Lawson were arrested up into Steve Lawson's trial. Okay, and yeah, it's reading a lot of court documents, but they're juicy, I promise. And we're going to watch some of the hearings that happened. And, you know, I said I wanted to cover this case in thoroughness. Because part of me was like, oh, do I really need to do all this? And the answer is yes. Yes, we're doing a thorough investigation, which means all of the pretrial motions and all of that. And I think y'all are going to be very, very surprised what we'll be talking about and reading about and seeing and being like, oh, yikes, this isn't great. This isn't great. So we'll do that. As for the rest of the schedule this week, we're just going to have to see how we get tomorrow and play it by ear. Yeah, we're not going to do 8:30 tomorrow because it's going to be a long night for me. So I can make sure all of that is put together for you all. So 10 a.m. tomorrow, Eastern time here. Go ahead, hit the notification bell so you don't miss when the link for that or the stream is set. And we're going to hang out all day tomorrow. You're going to get plenty of Llama time, a lot of snark, a lot of looks like that. You're going to get a lot of those. So prepare yourselves. So, all right, you guys. Well, thank you so much for being here today. We will be streaming the victim impact statements for Bryan Kohberger. So don't worry, you can join us here for those. Again, that's going to be July 23rd. They said, what, 9? So that's 11 a.m. Eastern time for that. Girl. I'm so angry about it. But anyway, we'll get into that. You'll just have to watch the future episodes to hear more of Llama's ranting. So, all right, you guys, until tomorrow, go forth and be amazing. And I hope you all have a wonderful day. Bye.